Risk or procedure? That's the question sitting underneath the headline tonight. And it's the wrong place to start unless we slow this all the way down. Because a $150,000 bond feels like a verdict to people who don't live inside courtrooms. It feels like a signal, a warning, a moral judgment. But bond isn't designed to answer whether someone is guilty. It's designed to answer whether the process can function without the defendant in custody. And that distinction matters more than ever right now, after John Patrick Roark, age 47, was arrested on January 16, 2026 in Odd, West Virginia. Attention shifted almost instantly to one number, one figure, one line on a court record: $150,000. Some people read that as proof the allegations must be overwhelming. Others read it as theatrical, inflated, or driven by public pressure. And both interpretations miss what bond actually does in the legal system. So tonight, we're not arguing outcomes. We're not predicting guilt. And we're not amplifying rumors. We're separating procedure from assumption, because this case has now crossed a line that matters. It has moved out of internet outrage and into formal criminal process. Arrest, arraignment, bond, filed felony allegations. That changes how this story should be read. And if you want to understand whether this case expands or collapses later, you have to understand what this moment actually represents. Let's start with the bond itself. Here's what most people get wrong. Bond is not punishment. It is not a sentence. It is not a declaration of guilt. Bond is a release condition set while a case moves forward. It answers a single question: can the defendant be released while still ensuring the court process works the way it's supposed to? When a magistrate sets bond at $150,000, they are not saying the case is proven. They are weighing risk factors based on limited, early information presented at arraignment. That information can include whether the defendant is likely to return for future court dates, whether there are public safety concerns, the seriousness and structure of the alleged offenses, the defendant's ties to the community, prior criminal history, if any, the judge's discretion under state guidelines. None of those factors equal guilt. They are risk management tools. And that's important here, because this story didn't begin in a courtroom. It began online, loudly, emotionally, with years of commentary, theories, accusations, and outrage directed at anyone connected to the Whittaker family. But outrage does not set bond. Evidence summaries do. This is the first moment where the system formally touches the case. And the system moves differently than social media. According to the record you're working from, Roark is currently being held at the Southern Regional Jail as this process begins. Whether bond can be posted depends on local rules and methods, which can include cash, property, or surety. But the principle stays the same regardless of how release is structured. Bond exists to manage risk, not to announce conclusions. So if you're looking at that $150,000 number and reading it as proof of guilt, pull back. That's not what the court is saying. The court is saying, this is the condition we're setting while we determine what is true. And there's one more procedural detail that often gets overlooked. Bond is often the first visible signal that the system is taking the next step seriously. But it is never the final word. Bond can be modified, reduced, increased, revoked, or rendered irrelevant by later filings. It's a starting condition, not an end point, which leads to the next question that actually matters. If bond is about risk, not guilt, What do police say they believe happened? Because now we leave speculation behind and step into the record. This is where online narratives usually fracture, because what matters first is not what people believe. It's what authorities allege in writing. According to police and court documents summarized in your materials, West Virginia State Police arrested Roark following what is described as a months-long investigation. The filings list 11 felony charges, 5 counts of financial exploitation of an incapacitated person, 5 counts of fraudulent schemes, 1 count of fraudulent use of an access device. That's not a headline. That's a charge list. So let's do this cleanly, not as a rumor storm, not as commentary, as an allegation map. Who is alleged to have done what? Authorities allege that Roark used the Whittaker family's images and identities to enrich himself, specifically through social media content and donation appeals. The complaint narrative describes him presenting himself online as a helper or intermediary, someone positioned as a liaison, while building trust with an audience that believed they were financially supporting the family. How does this relate to the Whittakers? According to the documents, investigators allege Roark began visiting and filming members of the Whittaker family, who are described as vulnerable. Some are described as having serious cognitive impairments. Some are described as being unable to provide meaningful consent. The alleged victims named in the filings include Larry Betty Lorraine, also spelled Laureen in some records, Timmy and Ray Whittaker. What harm is alleged? The complaint narrative alleges that donations intended to improve the Whittakers' living conditions were intercepted using Roark's personal address and financial credentials. The estimated amount involved exceeds $10,000, with activity described as beginning as early as May 2025 and continuing through late summer into September 2025. That's the core allegation, not what Facebook says, not what YouTube comments claim, what authorities allege in the record at this stage. An alleged pattern of using vulnerability and visibility to generate money while donors believed they were helping. The documents also note that another individual, Lawrence Eric Carroll, is described as a person of interest and not charged in the materials you provided. That distinction matters. Being named as a person of interest is not an accusation of guilt. It's an investigative designation. It means authorities are aware of someone's potential relevance, not that charges are imminent or warranted. And this is where misunderstandings begin. Not charged does not mean cleared. Charged does not mean convicted. It means one evidentiary track crossed a legal threshold before another, or alone. Which brings us back to the bond. A $150,000 bond doesn't exist in isolation. It sits on top of what police allege, what they believe they can show, and what a magistrate believes is necessary to manage risk while the case unfolds. And here's the part people don't like. Early in a case, courts do not see the full evidentiary picture. They see a summary, a probable cause narrative, a snapshot, not the full film. That's why bond decisions can change later, because they are made before discovery, before contested hearings, before motions to suppress, before cross-examination. This moment matters not because it proves anything, but because it marks the transition from accusation to adjudication, from attention to process. And once a case enters that lane, the rules change. The next question isn't how angry people are. It's how strong the evidence actually is. And that's where we go next. Because most people imagine evidence as a single dramatic reveal, a screenshot, a confession, a smoking gun. Real cases don't work that way. They're built in layers, and every layer has to survive legal pressure. In Part 2, we'll break down what investigators actually have to prove, category by category, and why this phase determines whether a case tightens or unravels. But before we get there, pause on this. Bond is not proof. Bond is not punishment. Bond is procedure. And procedure is where truth either holds or collapses. So here's the comment call, and keep it honest. One word only. Risk or procedure. Tell me why. Most people imagine evidence arriving all at once. One screenshot, one confession, one document that ends the argument. That's not how cases like this are built. They're built in layers, and every layer has to survive contact with defense attorneys, judges, and statutory definitions. Not public opinion, not outrage, not volume, which is why this stage matters more than the arrest itself. Because now the case isn't about what people believe happened. It's about what investigators can prove cleanly, legally, and in sequence. So let's slow this down and talk about what has to exist for charges like these to move forward. In a case involving alleged donation fraud and exploitation of incapacitated persons, investigators are not looking for vibes. They are looking for categories of proof that fit together without gaps. Start with the money. Financial cases live or die on traceability. Investigators need transaction histories that show where funds originated, how they moved, and where they landed. That means payment app records, bank statements, timestamps, routing data, and account ownership. It's not enough to show that money was donated. They have to show control. Who had access to the account? Who could withdraw funds? Who benefited? That distinction matters because receiving money and controlling money are not always legally identical. Next layer, communications. Investigators look for messages, posts, captions, live streams, direct messages, anything that directed people to send money. This is where intent gets tested. What claims were made while donations were being solicited? How were those claims framed? Was there a representation that funds would go directly to the Whittaker family? Was there language suggesting necessity, urgency, or exclusive access? Intent isn't inferred from anger. It's inferred from words and patterns. Then comes content. Authorities don't just look at what was posted. They look at how it was posted. Frequency, framing, monetization methods. Whether content featuring vulnerable individuals was tied directly to donation appeals. Whether the same individuals appeared repeatedly in fundraising contexts. Whether viewers were encouraged to believe they were participating in direct aid. Content establishes context. Context establishes whether actions cross statutory lines. Then come witnesses. Donors who believed they were helping the family. People who interacted with the defendant. Individuals who can confirm timelines, access, and representations made privately or publicly. In modern cases, the audience itself becomes part of the evidentiary structure. Not emotionally, but factually. Receipts matter. Transaction IDs matter. Screenshots matter. That's why your documents reference investigators seeking donor cooperation. That's not unusual. It's how digital-era cases get anchored in verifiable facts rather than impressions. And here's the part the public often misunderstands. Early in the process, you don't see everything. Not because nothing exists, but because the court process is not a public documentary. Evidence is gathered, organized, authenticated, and disclosed through procedure. Discovery doesn't happen on social media. It happens through filings, hearings, and court-ordered exchanges. That's why arrests often feel anticlimactic to people who expected a full reveal. The reveal comes later, or not at all, depending on what survives scrutiny. And this brings us to the pressure point, because evidence isn't just about what exists. It's about what can be proven beyond a reasonable doubt. That standard is unforgiving. It means timelines must align, accounts must match records, statements must be consistent, and access must be demonstrable. If even one critical link is weak, charges can narrow, or fail, or be reshaped entirely, which is why the next procedural move matters more than the arrest itself. What do prosecutors do next? Do they refine the allegations into a tight, focused case built around the strongest provable elements? Or do they widen the scope because corroboration supports additional charges, additional actors, or additional time frames? That choice tells you whether a case is consolidating or expanding. And this is where expectations collide with reality. The internet often wants cases to grow. More names, more villains, more collapse. But prosecutors don't build cases for narrative satisfaction. They build them for survivability. Sometimes that means charging less than the public expects. Sometimes it means waiting longer than people want. Which brings us to the unresolved question sitting underneath this entire story. If evidence has layers, and not all layers are public, who else could be affected by where those layers lead? That's not speculation. That's structure. Because cases expand for legal reasons, not emotional ones. And that's where we go next. In Part 3, we'll break down how and why cases like this either widen or stay narrow, and what signals actually matter if you're trying to understand which direction this one is heading. Until then, remember this. Evidence isn't loud. It's durable. And durability is what decides outcomes. By the time a case reaches this stage, the public usually wants one thing: more. More names. More arrests. More confirmation that everything they suspected was right. But the legal system doesn't operate on narrative momentum. It operates on thresholds. And those thresholds determine whether a case expands outward or collapses inward. So if you're watching this story and asking, is this going to get bigger? The only honest answer is, it depends on what the evidence can legally support, not what the audience expects. Let's slow this down and talk about how expansion actually happens. Cases do not expand because people are angry. They expand because new facts survive verification. There are only a few mechanisms that legitimately widen a criminal case, and all of them are procedural. The first is corroboration. When investigators receive new information, they don't act on it immediately. They test it. They look for independent confirmation. If multiple donors submit records that align, same payment handles, same timeframes, same representations, that doesn't just add volume. It adds reliability. Corroboration turns isolated claims into patterns. And patterns are what prosecutors use to justify additional charges or additional defendants. The second mechanism is financial tracing. Money leaves trails whether people intend it to or not. If investigators follow transaction histories and discover additional accounts, additional recipients, or additional routing paths, the scope can change fast. But here's the key detail. Finding more money does not automatically mean finding more defendants. Investigators have to establish control, access, and intent. An account appearing in a transaction chain isn't enough. They need to show who had authority, who benefited, and who knew what was happening. That's why financial expansion is slower than people expect. Every link has to be defensible in court. The third mechanism is communication evidence. Messages change cases. If investigators uncover communications showing coordination, planning, or division of roles, the legal exposure shifts. Conversations can establish knowledge. They can establish agreement. They can establish who directed what and when. This is where cases sometimes pivot from single defendant to multi-defendant structures. But it only happens if messages are explicit enough to survive interpretation battles. Ambiguity favors defense. Clarity favors charges. The fourth mechanism is witness repositioning. Sometimes someone initially treated as peripheral becomes central because new information reframes their role. That doesn't mean investigators missed something earlier. It means the picture changed once additional facts were layered in. But this doesn't happen casually. Witness repositioning usually follows verified contradictions, statements that don't align with records, timelines that don't hold, access claims that fall apart under documentation. And even then, prosecutors move carefully, because expanding a case too fast can damage it. Which brings us to the opposite truth, and the one people struggle with the most. Most cases don't expand dramatically. They consolidate. Prosecutors often narrow cases on purpose. They focus on the cleanest, strongest, most provable core, not because other conduct didn't happen, but because proving everything can risk proving nothing. This is where public expectation and legal reality diverge. The audience wants the whole story charged. The court wants the strongest story proven. So sometimes investigators leave conduct uncharged. Sometimes they sever threads. Sometimes they reserve allegations for later phases that never arrive. That's not failure. That's strategy. And it's why seeing only one arrest in a story with multiple names doesn't mean the system is broken. It often means the system is disciplined. Now, let's address the part people keep circling. The presence of a person of interest. That phrase carries weight online, but legally it's neutral. It means investigators believe someone may have information relevant to the case. It does not mean they have probable cause. It does not mean charges are pending. And it certainly does not mean guilt has been established. Naming someone as a person of interest can serve multiple purposes. It can signal that investigators are still gathering information. It can encourage witnesses to come forward. It can clarify boundaries between charged conduct and ongoing inquiry. But it is not a promise of future action. And here's where people often misread silence. When authorities don't comment beyond what's in the record, it's not because nothing is happening. It's because commentary can contaminate cases. Statements can limit options. Premature accusations can create defenses. So restraint isn't absence. It's containment, which brings us back to the central fork in the road. At this stage, cases usually move in one of two directions. They either tighten, fewer claims, stronger proof, clearer roles, or they widen, more defendants, more counts, broader timelines. And the signal for which direction is coming isn't social media reaction. It's filings. If prosecutors file amended complaints, superseding charges, or additional warrants, that suggests expansion. If filings refine language, consolidate counts, or emphasize specific transactions, that suggests containment. And if nothing new appears for a while, that doesn't mean nothing is happening. It means preparation is underway, which leads to the uncomfortable truth. Sometimes the public expects a sweeping reckoning, and the legal system delivers something narrower, quieter, and more precise. That can feel unsatisfying, but it's often intentional, because the legal system isn't designed to validate suspicion. It's designed to test claims under rules that favor caution over spectacle. Now, let's connect this back to the bond, because this is where the pieces intersect. Bond is often the first visible procedural move. Expansion or containment is determined by what follows. A high bond does not guarantee a big case. A narrow charge list does not guarantee a small one. What matters is how evidence holds up once it's challenged. And that challenge is coming. Defense attorneys don't argue online. They argue in motions. They test probable cause. They challenge intent. They question consent. They scrutinize access. Every allegation will be pressed. That pressure either fractures the case or hardens it. And that's why this moment matters. Not because it confirms anything, but because it initiates the process that decides everything. So if you're watching and wondering whether more names will appear, more arrests will follow, or more revelations are coming, the responsible answer is this. Watch the record. Watch what gets filed. Watch what gets amended. Watch what gets withdrawn. Ignore the noise. Because cases don't grow to satisfy curiosity. They grow when facts force them to. And sometimes they stop growing because restraint preserves them. That's where this turns from observation into understanding. Until then, remember this. The size of a case is not a measure of its strength. Its survivability is. There is a moment in every criminal case where momentum stops being emotional and starts being procedural. This is that moment. Up to now, attention has been driven by outrage, speculation, and the sheer visibility of the story. But from here forward, the direction of the case is decided by filings, hearings, and evidenti pressure. Quiet steps, technical steps, steps most people never see, but that determine everything. So if you want to understand whether this case grows or contracts, you have to know what to watch for now. Because expansion doesn't happen by accident, and collapse doesn't happen overnight. They both happen through signals. The first signal is how prosecutors frame the case when it moves beyond the initial complaint. The arrest affidavit and charging documents are starting points. They are built on probable cause, not proof beyond a reasonable doubt. That's a lower threshold, and everyone involved knows it. The next phase is where prosecutors show their hand. Do they file amended complaints that clarify language, tighten timelines, and specify transactions? That's usually a sign of consolidation, a move toward a leaner, more defensible case. Or do they file superseding charges, add counts, or expand the alleged time period? That's a sign of growth, but only if those additions are specific and supported, not vague. Vague expansion is a red flag. Precise expansion is a signal of confidence. The second signal is how the defense responds. Defense attorneys don't argue morality. They argue elements. They test whether each charge actually fits the statute. They challenge whether the alleged victims meet the legal definition of incapacitated under state law. They examine whether consent, even limited consent, was present. They question whether funds were misrepresented or merely redirected. They probe whether content creation crosses into exploitation under the law or remains protected conduct. And this is where weak cases start to shrink. If defense motions expose gaps, unclear control of accounts, ambiguous representations, Inconsistent timelines. Prosecutors have two choices. They can fight, or they can narrow. Narrowing isn't retreat. It's triage. Prosecutors would rather win a smaller case than lose a larger one. That's not cynical. That's their job. The third signal is discovery. Discovery is where cases either gain weight or lose it. This is when evidence is exchanged, when defense sees transaction records, when communications are produced, when content archives are disclosed, when witness lists solidify. And here's the thing most people don't understand. Discovery is where surprises happen, for both sides. Sometimes evidence is stronger than expected, cleaner, more consistent. That's when cases harden. Other times, evidence doesn't line up the way investigators believed it did. Accounts overlap. Access isn't exclusive. Statements conflict. That's when cases thin out. This is why silence during discovery isn't suspicious. It's necessary, because talking before discovery closes can lock prosecutors into positions they later wish they could adjust. The fourth signal is whether protective orders or special conditions are requested. In cases involving vulnerable individuals, courts sometimes impose conditions beyond standard bond requirements, restrictions on contact, limitations on content creation, prohibitions on monetization involving specific individuals. If prosecutors seek those conditions, it suggests concern about ongoing risk, not guilt, risk. If they don't, that tells you something too. Neither outcome proves anything, but both indicate how the system is assessing exposure going forward. The fifth signal is timing. Fast cases aren't always strong cases. Slow cases aren't always weak ones. But erratic cases, sudden filings followed by long gaps without explanation, often indicate instability. Deliberate pacing usually means the prosecution is stress testing its own theory before committing further. This matters here because public attention is high. Pressure exists, and pressure can tempt overreach. Overreach is dangerous. Charging too much, too fast, can hand the defense arguments it wouldn't otherwise have. It can introduce evidentiary conflicts that don't need to exist. It can complicate jury perception. So restraint at this stage is not hesitation. It's insulation. Now, let's address the question people keep asking directly. Why not charge everyone now? Because the law doesn't work that way. Charging decisions are not moral judgments. They are probability assessments. Prosecutors ask one question before every filing. Can we prove this beyond a reasonable doubt? If the answer is anything less than yes, they wait. That doesn't mean other conduct is ignored. It means it's not ready. And sometimes it never becomes ready. That's the part people struggle to accept. The legal system does not exist to validate public suspicion. It exists to resolve provable claims. Which brings us to the risk of collapse. Cases collapse when key elements can't be proven cleanly. If prosecutors can't establish exclusive control over funds, financial exploitation charges weaken. If intent can't be shown clearly through communications or representations, fraud counts narrow. If the legal definition of incapacity isn't met for specific individuals, those counts fall away. Collapse rarely looks dramatic. It looks incremental. Charges dismissed. Counts reduced. Language softened. To the public, it feels like something was taken away. To the system, it feels like precision. And here's the uncomfortable truth. A case that collapses is not always a false case. And a case that expands is not always a righteous one. Outcomes are determined by rules, not feelings. Which brings us to the most important part of this phase: protection. Because regardless of how the legal case moves, the people at the center of this story are not abstract. They are human beings described in the record as profoundly vulnerable, individuals with serious impairments, individuals who have been treated, historically, as content rather than as people. The legal process has one obligation. The public has another. The system's obligation is to prove or disprove allegations fairly. The public's obligation is not to cause additional harm while that happens. That means not amplifying unverified fundraising links, not directing attention toward intermediaries without confirmation, not substituting certainty for caution. Empathy without verification can still be exploited, which is why this stage matters so much. From here forward, speculation doesn't help. Documentation does. If donors exist with records, receipts, transaction IDs, screenshots, those are not drama. Those are evidence. And they matter only when handled properly through official channels. And this is where we end part 4. At a fork. One path leads to expansion through corroboration, documentation, and procedural confidence. The other leads to containment through refinement, narrowing, and proof-focused restraint. Neither path will satisfy everyone. Only one path satisfies the law, not based on noise, based on record. That's where this stops being a story and becomes a case. By now, the emotional phase of this story should be over. Not because emotions aren't understandable, they are, but because they no longer move the case. Procedure does. From this point forward, everything that matters happens quietly, through documents, dates, and decisions that don't trend but determine outcomes. So let's lay out the roadmap. Not speculation, not prediction. What actually happens next? Right now, the procedural facts are simple. An arrest has occurred. An arraignment has taken place. Bond has been set at $150,000. 11 felony charges are pending. That's the known terrain. From here, the case moves into a phase most people never see, but that decides almost everything. Pretrial process. The first step is scheduling. The court will set dates for preliminary hearings, motion deadlines, and future appearances. These aren't dramatic events. They're structural. They determine how much time each side has to prepare, respond, and challenge. Timing here is strategic. Too fast, and the defense may argue inadequate preparation. Too slow, and the prosecution risks losing momentum or clarity. The court balances both. Next comes preliminary hearings or probable cause review, depending on jurisdictional procedure. This is where charges get tested for the first time. Not for guilt, for sufficiency. The question isn't, did this happen? It's, is there enough here to keep going? Some charges survive easily. Some get narrowed. Some disappear quietly. That's normal. Charges at this stage are not sacred. They're provisional. Then comes discovery. This is where theory meets reality. Evidence is exchanged. Records are disclosed. Statements are reviewed. Timelines are compared. And this is where cases either gain gravity or lose weight. Discovery doesn't care about outrage. It cares about alignment. Do transaction records match allegations? Do communications support intent? Do access claims hold up under documentation? If they do, the case firms up. If they don't, the case contracts. Most of this happens without public commentary, and that silence is not avoidance. It's containment, because statements made now can limit options later. After discovery, motions begin. Defense motions to dismiss. Motions to suppress evidence. Challenges to statutory definitions. This is where the law gets precise. Words matter. Definitions matter. Thresholds matter. And this is where a case's true strength shows itself. Strong cases survive multiple motions with minimal damage. Weak cases erode piece by piece. Then comes a decision point prosecutors never announce publicly, but always face privately. Do we proceed as charged? Do we amend? Do we narrow? Do we resolve? Resolution doesn't always mean trial, and it doesn't always mean plea. It means clarity. Sometimes that clarity supports escalation. Sometimes it supports restraint. And sometimes it supports resolution without spectacle. Now let's talk about what the public should actually watch for, not emotionally, but intelligently. Watch filings, not posts. Court documents matter. Language shifts matter. Charge adjustments matter. If allegations become more specific over time, that's confidence. If language becomes broader or vaguer, that's caution. Watch consistency. Do prosecutors repeat the same factual theory across filings? Or does it change as pressure increases? Consistency signals preparation. Inconsistency signals stress. Watch who speaks and who doesn't. If authorities stop naming individuals beyond the charged defendant, that's usually intentional. If new names appear in formal documents, that's meaningful. Silence is not protection. Speech in filings is commitment. And watch timing. If this case moves deliberately but steadily, it's being handled carefully. If it lurches forward and stalls repeatedly, something is being reevaluated. Now, there's one more responsibility that sits outside the courtroom: protecting the people at the center of this. The Whittaker family members described in the record are not symbols. They are individuals described as profoundly vulnerable, with serious impairments and long histories of exposure. Legal outcomes won't erase that vulnerability, which means the public still has a role, but a limited one. That role is caution. Don't send money through unverified channels. Don't amplify urgent calls that bypass documentation. Don't let empathy override verification. If you donated in the past and you have records, transaction IDs, receipts, screenshots, those are facts, not drama. They belong with investigators, not comment sections. And if you don't have records, pause. Waiting causes less harm than acting on uncertainty. This is how real harm is prevented while real cases unfold. Now, let's answer the question underneath everything. What decides whether this case expands or collapses? Not belief, not volume, not pressure. Proof. And proof is tested slowly, deliberately, and often out of sight. Sometimes that leads to broader accountability. Sometimes it leads to narrower conclusions. Neither outcome validates or invalidates public feeling. It validates the process. And that's where we end this series. Not with certainty, with structure. Because structure is what separates investigation from rumor, procedure from outrage, and justice from noise. So here's the final question, and this one actually matters. Now that you understand what bond means, what allegations are on record, how evidence is tested, and how cases expand or narrow, do you think this case is heading toward expansion or containment? One word. Tell me why. Thank you for watching this video. Click here to watch another video that might interest you.